Hello, my name is Guthrie Coughlin, and I'm a graduate student at Grand Canyon University studying special education with moderate to severe disabilities. Today, I will be discussing what is included in procedural safeguards because I believe it is important that parents and guardians of students with moderate to severe disabilities have a clear understanding of their legal rights that these procedural safeguards give them. Procedural safeguards must be reviewed by and accessible to families of students that have an IEP, including those with moderate to severe disabilities. At least once a year, parents must receive from the local school district a complete explanation of all the procedural safeguards in accordance with the IDEA Act. Parents can also request a copy of this document at any time. It is important to have this document accessible for parents and answer any questions or concerns they may have. The first procedural safeguard I want to discuss today is the right for the parents and guardians to participate in all their child's education meetings, including IEP meetings. Parents and guardians have the right to attend all education meetings for their child and even have the right to call for an IEP meeting at any time. It is also the responsibility of the IEP team, specifically the case manager, to host the IEP meeting at an appropriate time for the parents and guardians to attend. Another procedural safeguard is the right to access educational records of your child and receive an explanation of their child's school records. If there are any discrepancies, the parents and guardians may ask for a correction. Another procedural safeguard is confidentiality of information. It is the school's responsibility to protect their students' confidentiality, such as the student's name, address, medical needs, and social security number, amongst many other things. Informed consent or parent consent is a procedural safeguard that ensures that before evaluating the student and before offering special education services for the first time, the school must first inform the parents and guardians what is involved. The parents must first give signed permission before the school can move forward. Prior written notice is a procedural safeguard that states the IEP team must give prior notice before it amends the student's IEP in any way. Amending IEP goals such as services and/or accommodations provided. Parents must receive prior written notice for these changes and an explanation of why they are doing this. If parents and guardians of the student with disabilities disagrees with the proposed changes in their child's IEP, including the services provided and the placement of them, they can invoke their stay put rights. Stay put rights are a procedural safeguard that keeps the student's IEP in place while the parents and the school collaborate and come up with a compromise. The next procedural safeguard I want to cover is providing understandable language. When a school provides prior written notice or any communication to the parents of those with students with disabilities, it must contain language that is native and understandable to the general public. Independent educational evaluations are a right to those with disabilities and their families, stating that if the families disagree with the results of the school's initial evaluation of the student, the parents and guardians have the right to an independent educational evaluation from someone not employed with the school district. The school must consider the results, but they do not have to accept the evaluation results. The last procedural safeguard that I'm going to cover is dispute resolution options. Parents and guardians have the right to disagree with the school regarding their child's IEP. Negotiation is an option that offers a collaborative solution. Parents and guardians can talk to the IEP team and sometimes figure out a compromise together. If that doesn't work, The use of a third-party mediator is effective when tensions are high, and they can help resolve the dispute. Parents and guardians also have the right to submit a written complaint to the school. Through due process, a hearing will be held and a decision will be made for the complaint filed. Parents and guardians also have the right to file a complaint about the school and the services provided to their child to the State Education Board, stating how the school is violating their rights under IDEA and their procedural safeguards. As I end this video, I first want to leave you with 2 recommendations of parents and guardians resources that provide additional information of procedural safeguards. My first recommendation is kind of simple. It's just visiting your local school district website, because they will have procedural safeguards posted and they'll have contact information of the person if you have any questions or concerns or any grievances. They are there to help. If you want to do your own research, I recommend visiting parentcenterhub.org and searching for procedural safeguards in the search bar. The website presents all procedural safeguards in appropriate language and is easy to navigate. Furthermore, the website also offers in-depth information of your dispute resolution options and effective ways to communicate with schools. Thank you for taking the time to watch this video on procedural safeguards, and I hope that you'll take something away from it. Have a grateful day.